speaker, and Twigg, also from KMB Law, a commercial real estate associate in our group. Anne's presentation today will focus on closing during COVID, agreement of purchase and sell clauses, and preparing for day of closing challenges. As you know, it's been an interesting time since COVID, and certainly we have seen some changes on how buyers and vendors are dealing with the issues that COVID has created. And we're here to assist you in that process, whether you or your clients, and Em will speak to that. So I'll, on that note, Em, go ahead.
Great. Thank you, Jennifer. Good morning, everyone. As Jennifer mentioned, I'm an associate in our real estate group. I handle purchases, sales, refinancing, and what I really like is weird title issues that come up and how to deal with them. I personally started my career doing real estate litigation, and then morphed into working for developers and then doing more transactional work. So whenever I look at these scenarios, I remember back to my days of litigating these matters. And so now that I am in a new role where I focus more on the transactional aspects and helping people with agreements of purchase and sale, I keep that in mind. So that's going to inform a lot of what we are going to talk about to hopefully keep everybody out of court, and so that we can have smooth closings, you know, and know we have a comfort of that about that from the beginning. So we'll talk about COVID clauses with that view, and some of the standard ones that are floating around out there. And then we're going to talk about some of the new challenges that are facing us in closings and how we can best address that in creative ways. And so we can go to our first COVID clause. So this is the one that I often see first in agreements, and you'll see that it says that the buyer and seller agree that if there is a delay in land registration that would affect the actual registration from the closing date, then the buyer and seller hereby agree to extend the completion date of this transaction until the next possible date. So I'm going to pause there and let's talk about the triggering events. So the underlying portion is the delay in land registration. The first issue that we're seeing with this is that, what does this mean? Do you mean a closure of the LRO or closure of the banks? This is what we think this clause is intended to cover. So what we've been doing is trying to, if it comes to us at a point where we're negotiating this, I will change that to specify that it's due to the closure of the LRO or the banks. But the issue with this is that luckily, they're not closing, and so we hope that they're not going to close. Land Registry Office, even though they have decreased hours, they're still processing deals. Certain matters might take a little longer, but we're still seeing that you can actually still register. There's 2 steps in registration. You'll if it's an electronic registration, the lawyer has a key and they're registering it on their computer remotely. So transfers are being registered, mortgages are being registered. Then there's usually 30 days for the Land Registry Office to process those. So that's still happening. And so that's kind of the main issue with this. And what I want to know when somebody comes to me with a clause like this is, why are we putting this in here? Let's find out why the parties want this clause. I know everybody is you know, worried about the uncertainty about things being closed, but what we are seeing is that luckily it's still, everything's still open. So the other issue we have with this clause is that the buyer and seller agree to extend the next possible date. It doesn't say kind of how the parties come together. Is it in writing? How are they extending? So you know, you might want to think about that when you're coming across a clause like this, if you have the opportunity to tweak it. Just because people are presenting it as a standard clause doesn't mean you can't change it, or ask people in the negotiation process, what is the intention of putting this in here? And let's see if we can tweak it that it actually reflects the party's intentions. The second half of this clause is more troubling to me, is that we'll go to the clause, buyer's title insurer has provided gap coverage to the buyer, and that so if you cannot close, you cannot do the registration, then in the event that the buyer's title insurer has gap coverage and closing funds have been paid to the seller solicitor in trust, this says that the keys may be released to the buyer, possession transferred, even though title hasn't been transferred, and then it tries to address the issue of risk and expenses in the next part. So I'll kind of break down the problems with this. First, the big problem from the seller side is that your money is held in trust by your lawyer, meaning the idea in an escrow closing is that it just sits there. The lawyer cannot release it to parties that you want to pay out. So one of them, the most important probably, is the mortgage being paid out. And depending on what kind of mortgage is on that property, you might be facing high per diem interest rates. So I think it's unclear in this section whether the buyer is responsible for that. That's not great for the buyer either. And then the other issue of transferring, possession in this way is it mentions risk, but it doesn't talk more about that. I think you should really put more in what does that look like in an actual transaction, because the problem is if a buyer takes possession before they take title, they don't have a normal insurable risk in that scenario. So what kind of insurance are you asking them to get? Are there policies that would be able to cover in this situation? Because you wouldn't want the seller to be liable for different things. So normally escrow provisions really spell out things more. And so I would encourage everybody, if they want to set up some sort of escrow provision, maybe have a chat with a lawyer and tell them about your situation, because every situation is very unique and we're going to tailor it to that situation. So especially in this way. So really watch out for clauses like this, because you don't want to, for both sides, have that risk of really having things tied up and not being able to deal with it. So
may I ask a question?
Sure.
Sounds like what you're saying for this particular clause is there's a lot of clause out there. People are saying this is standard. Make sure that you if you're going to agree to one of these clauses, even though we seem to be nearing the end of COVID, no one really knows. There might be another phase. Make sure that you have a lawyer review it so that we cover and think about the different situations for you and help you draft it in a way that, as you said, will cover the specifics of your situation, right?
Yes, because you want somebody with a perspective of how could this be litigated? What is the risk? And the way I approach everybody is that, we all have great things to bring to the table. Agents, they know their clients, they know the situation. So I really see ourselves as a team, that they're going to bring their perspective to me, and I'm going to bring my perspective, and whoever the lawyer is on that deal will bring their perspective. And a lawyer's perspective really is what are the risks? How do we draft this? And how do we avoid litigation? So I think that's a great point.
How to close the deal, yeah.
Yeah, how to close the deal, because we want to have it done smoothly. Because the issue is, sometimes people come to me and say, oh, Anne, but, you could get out of the deal this way, right? With something like this. But sometimes you want to draft it in a way where you don't have to do that, right? Where you don't have to be going to your lawyer day of closing and having a letter fight about it. You want to set us up from the beginning so that we can try to anticipate. And, having experienced lawyers who have seen these fights play out brings that level of, foresight into it, because our job is to imagine these worst case scenarios and how do we draft to try to avoid them.
Okay.
Great, thanks. So I'll move on to my second COVID clause that I've seen in a lot of agreements. And so this one to me is a little bit more interesting, actually, because it raises a lot more questions for me. It says that if either party, the buyer or seller, becomes the subject of a mandatory virus quarantine at the time of performance, and it results in the party's inability to complete the transaction, then it becomes automatically extended. Before I move on to that, let's talk about the first bolded points. So again, this is very vague to me. What is a COVID virus quarantine? We've been seeing this in the news where, you know, people have to stay home for 14 days. And so if that's what we're thinking, because we're trying to normally pair these with electronic signatures or finding creative ways to get our parties to sign, is that really the intention of this? Do you want an automatic extension when somebody's just at home and can still, you know, conceivably complete the transaction? The fear I have with this kind of clause is that people could misuse it for ulterior motives. So you would want to have this specified more if you wanted to use a clause like that. So talk to your client, talk to the other side, and try to find out, what are they trying to achieve here? Is the person, you know, contemplating a scenario where they're being hospitalized? You know, that obviously is a different scenario. You know, we wouldn't want to have people just delay things automatically for ulterior motives just because they maybe tested positive, maybe are fine and could conceivably close the transaction. It's just too vague and causes too much uncertainty here. The next part is that it contemplates an automatic extension of 14 days, which is just seems to have been just chosen at some point. Probably, you know, going with that 14-day rule that we've been hearing about, but we're not really sure why this is just being automatically extended. It flies in contravention of time of the essence provisions later on in the drafting as well. So it causes some confusion as to how do you still work towards a closing diligently when you've already been automatically extended. It's interesting because this clause tries to cover the problems in itself by saying unless otherwise mutually agreed to by the parties. But again, I'd caution people on putting in automatic extensions and then, you know, try to read the clause in its whole. Are the parts of that clause working together or not? And, you know, this idea of trying to act in good faith, and, you know, that in itself, the parties agreeing to be honest, to me is not as effective as being more particular in your drafting. So think of things as, what is the trigger date? What am I trying to achieve? Is my language very specific for those scenarios? How could my language be misused and constructed? Because you don't want to be in a scenario where you've thought that this is going to cover your situation in a particular way, and then later you're stuck in litigation, and then you have some creative students coming up with some ideas of how this clause can be, you know, misinterpreted from your original idea. So that itself is interesting. So the point about this one, I'd really want to see narrowed down, and also it helps when you use the electronic signature clause. So it allows the parties to sign electronically. What's interesting about this is that we're getting very good support from the Law Society about how lawyers should be, you know, meeting with their clients electronically and witnessing those signatures. And we're also getting help from title insurance for coverage for electronic signatures as well. So what I've liked about it is that, you know, we can probably cover most scenarios that, even if somebody is affected by this, to actually close if we have more ability to electronically sign and meet with the clients and not require paper copies. And I appreciate that the Law Society has helped us with guidelines about how to do that to ensure that we prevent against fraud. And you know, now we have technology, so if your client has that ability, you can ask them if they're comfortable with that, and know that, you know, there are title insurance coverages as well there. And so I'll kind of speak high level about what I talk about what I talk about with my clients whenever somebody is coming to me with this clause, because as you said, Jennifer, sometimes people think about these as standard clauses just because they're written in a certain way or they're seeing the same clause a lot. But what I really go through with the clients and other parties like agents is that let's take a step back. Why are we putting this clause in? And the other thing you want to think about is if we are involved in the negotiation stage with the other side and the other side has presented a clause like this, try to consider your audience. What kind of person are we talking to, and why do you think they put this clause in? Usually when I am involved in the negotiations, I'll try to change the clause as minimally as possible, just as a strategy, so that I don't immediately get somebody's backup, but that I'm actually trying to change the important substance of it and try to explain to them why I'm doing that, so that I don't get an immediate no, but there's a dialogue started. So first step usually would be to talk to, the client will talk to their agent, and client talks to their lawyers. We have a discussion about that. We find out how our audience might react to it, and together we'll decide how we're going to approach this and tweak it. And then we always try to explain why these changes being made, and mention that the fact that just because they're out there, I like highlighting the fact that debunking this idea of a standard clause somehow provides some comfort. Usually that's the intention of why somebody says that, but to me, a standard clause is more dangerous because it hasn't been tailored to this transaction, and it could result in situations that we didn't expect. So those are kind of the main things I think about, and each situation will see how best to approach these matters.
So Anne, can you speak to us, exactly, about what have you seen these days in terms of closing day challenges and what we are doing to ensure that on the day of closing, these deals are actually closing?
That's a great question. So, now we're moving on to, now we're involved with the deal, we're close to closing, what are we seeing? And so the big issues that we're seeing is, first is transactions that are happening on the same day. Your client is trying to buy and sell on the same day. On a good day, this was very challenging, and now with bank decreased hours, there's lineups across, I waited at the bank personally for half an hour one day just to get in, because they have decreased number of people they're letting in at a time. So moving money even before COVID was tough on the same day, because just say you're waiting for funds from your sale and you need it for your purchase. If you get your funds at 4:45 and we register that transfer at that point, that for your sale, that doesn't give us any time to then complete your purchase. But the problem with that is you're defaulting on your obligations, and yet that party who delayed you hasn't breached their contract. So what I recommend,
right? Your recommendation would be to try and avoid doing same-day closings in the midst of COVID.
Exactly. So if we can do that, and the thing that can help you with that is bridge financing. And so bridge financing will allow you to buy first and then sell later. And so you can talk to your bank about how that looks like for you. There is some cost to it, but depending on your situation, it might be very minimal. They usually require 48 hours to process it. So I would recommend talking about bridge financing early, trying to get it in place, find out what you need to give to your bank, how much notice, and then it can reduce a lot of stress. So that's the ideal situation. And then, like you said, choosing a closing date now will help us out as well. So going back to the drafting stage, historically, people really like having closings at the end of the month. And so if we can change, when we do closings, that will help a lot. And please try to avoid Friday closings, because a lot of times you'll choose a Friday date and then we have to pay interest later. It just provides a lot more, issues in that scenario. And then I've spoken about related transactions as well. Think about the other transactions happening on that day. If you're buying, selling, there might be 4 other transactions happening, each party buying and selling on the same date. So you could have a domino effect based on that. So,
That's great. Thank you, Anne, for your presentation. I would like to add, it's not, at the end of the day, we want to close the deals for you. So whether you're a purchaser or a realtor, it's not just the lineups at the banks. It's also the wires. If you've had to wire funds in the midst of COVID, you will know that it's very difficult. Often wires that are from a bank to a different bank that are made past noon will not reach the destination till the following day. And if you're a realtor or an experienced purchaser watching this webinar, you will know that often our deals don't close till 4 or 3, or we don't get funds from the mortgage till 2 or 3, very late in the afternoon. So it makes it very, very difficult to close deals. That the financial aspect is the most difficult. So another thing I think Anne will agree is that we try and ask clients now to deposit their funds the day before, whereas on a typical non-COVID period, we may say as long as your funds are in our account by noon, there's no issues. So we try and avoid that as much as possible to make sure that our deals close on the date that they're scheduled to close. But thank you, Anne. It was a great presentation.